Thank you. Be seated. Court is now ready to hear arguments from appellees Lionel, Meno, and others.
May it please the court, Ms. Hunter will present argument for the appellees Lionel R. Meno and others.
Good morning, Your Honors. Senate Bill 7 is a complex funding mechanism for the system of education in Texas. The decision before the court this morning, however, I think boils down to two questions. There are challenges from property-rich districts and challenges from property-poor districts. The challenges from the property-rich districts boil down to the question of whether the legislature has the authority to consolidate or otherwise change the boundaries of school districts. And I think the case law resoundingly says that the legislature does have that power. If that is true, then the legislature certainly has the power to offer districts and the trustees of districts some choices to avoid what they have characterized as draconian measures. On the side of the challenges that come from the low-wealth districts, the questions boil down to whether a system in which 98% of the money is equalized meets your standard in Edgewood 1 for a substantially equal system. I think that the answer to that question has to be yes, that is substantially equal. And if that's the case, the other questions presented, excuse me, Your Honor.
But is it efficient?
You have defined efficiency in Edgewood 1 and repeated in Edgewood 2 and Edgewood 3 that the standard that you are holding the state for efficiency is that there will be substantially equal access to educational resources regardless of the school district that you live in. That wealth should not drive, the wealth of the district that you live in should not drive the ability to raise educational funds.
So is your argument that the state can level down to whatever it wants to and it will be an efficient system?
The standard, Your Honor, is that that there be equal access. What the district court believed, and I believe what runs through the Edgewood 1 and Edgewood 2 and Edgewood 3 opinions, is that once you get school districts in a position where they do have equal access, where there's not vast disparities in the system, the political process itself will work to bring up the level of education for all children in Texas. But until you get school districts into that position, there isn't that political force. There's no reason for them to cooperate. There's no reason for them to do anything but diverge from each other in their approach to the legislature.
Ms. Hunter, how can a gap that ranges in the description of some at $600 per child and by Mr. Kaufman in his opening argument as potentially as much as $26,000 represent substantially equal access?
Your Honor, I think what you have to do is take a look at the system of wealth in Texas, take a look at the property districts in Texas, take a look at where this case started. When this court first considered the case, there was 700 to 1 disparity between the wealth of districts. Senate Bill 7, even in the unequalized parts of it, brings that down to 28 to 1. With the equalization, once the legislature catches up to the tax rate response, and within $1.50, that's brought to 1 to 1.36. That is tremendous progress given the nature of the property districts in Texas and the diversity of the wealth. You asked Mr. Luna the question as to whether or not what this amounted to was it just that the legislature needed to appropriate $600 million more. That's not what's important about the provisions of Chapter 36. It's not the amount of money that the legislature is able to recover from rich districts. That helps put more money into Chapter 16 and helps to equalize funding. But what's critical about what Senate Bill 7 does is the reduction of the wealth available to $280,000 per school district. That is what you were talking about when you talked about the vast disparities. And it's by bringing that every school district to $280,000 that Senate Bill 7 accomplishes what it does.
I wasn't asking if that would have satisfied Mr. Kaufman. I was interested in whether
well, in
that
Edgewood
was the
too,
sole
Your
ground
Honor,
for complaints of the rich district.
if you look at your Edgewood 2 opinion on page 496, you talk about Senate Bill 1, and then even if the approach of Senate Bill 1 produces a more equitable utilization of state educational dollars, it does not remedy the major causes of the wide opportunity gaps between rich and poor districts. Senate Bill 7 does that.
The Edgewood appellants argue that it's not even feasible for the state to, quote, catch up or to accomplish, quote, promised full funding. What's your response to that?
The Edgewood plaintiffs, Your Honor,
Argue that it's not even feasible for the state to catch up or accomplish, quote, promised full funding. What's your response to that?
well, Your Honor, I don't know that you can prejudge what the legislature is promised to do in the next legislative session. The bill requires funding to a particular level. I think you have to take the legislature on its word that that's what it intends to do. If in fact it doesn't appropriate to the level committed, then a new case is presented to the courts. But at this point, Mr. Kaufman's asking you to rule that you don't believe that the legislature will fund the bill.
If it doesn't, would that make his arguments good?
I think I would have to wait to see what they did, Your Honor. I mean, if they approximately fund it, that's a fact question for sure. But what's critical, you asked Mr. Kaufman how he defined property poor. And what he indicated was that a property poor district is one that had less than $100,000 of wealth. Under Senate Bill 7, 85% of the districts of the students in Texas reside in districts of property wealth of $205,000. What Senate Bill 7 achieves is that every school district, the poorest school district in Texas within the $1.50 system, is equivalent to a $205,000 system. 85% of the students have no gap at all in the funding. The only gap occurs beyond that equalized level, and then the gap is incremental from there to the top, the very wealthiest district. It's not 600 for 15% of the students. It's only 600 at the very top.
Did I hear you answer in response to Justice Heck's question, not directly but indirectly, that if the transition phase were the final phase of the state's answer to Edgewood 3 and 1 and 2, to all the Edgewood opinions, that would probably not be constitutional? In other words, if it were not for the promise of what's going to happen in the next session of the legislature and after the transition is finished, that would not meet constitutional muster?
Well, Your Honor, in the transitional phase, we're talking about a 28-to-1 average ratio between wealth in districts. That's certainly very much better than 700-to-1. It's not the promise of Senate Bill 7. It's not the bill that we're presenting to you. The bill we're presenting to you, once you get over the transition and once the legislature has an opportunity each biennium to catch up with tax response, is a system which brings it to 1 to 1.36. The district court found that to be an acceptable standard. It found that when 98% of the wealth was in the system, that was an acceptable standard. I don't feel as though it's my position to offer you a standard from my own experience in terms of whether the other 28-to-1 would be constitutional or not. But I would say to you that it's certainly a vast improvement over the bill that or the system that you declared unconstitutional. The very fact of reducing property wealth in all districts to $280,000 is a tremendous solution to the disparity that offended this court in Edgewood 1 and Edgewood 2 and Edgewood 3. Continuing, yes.
On what basis did the legislature determine that $280,000 of property value was a figure to be used? I mean, where did that come from?
Well, I'm not exactly sure, Your Honor. The $280,000 is a figure that made some sense in terms of what the legislature could fund to, made some sense in terms of a logical cutoff point, made some sense in the context of Senate Bill 351, having used a similar figure in terms of what the CED base figure was for for equity.
If Mr. Kaufman says a minimum educational needs for children is irrelevant in this inquiry, Mr. Thompson says his view of the minimum educational requirements is what it takes for a district to be accredited. Does $280,000 have anything to do with accreditation of a school district, or what is reasonably expected by the citizens of Texas for educating their kids? Or, I mean, does it have anything to do with the cost of education?
I don't think it does, Your Honor. I mean, I think what we're looking at is how to bring the system into some equity between school districts so that they each have an ability to get similar resources from the property tax base.
Irrespective of the cost of education.
Well, I think the cost of education is important, you know, in the whole scheme. I think that that's addressed in Senate Bill 7 and addressed in the funding system. It is addressed through the basic allotment in Tier 2. It's addressed to the amount that the state is equalizing to. But it's the constitutional standard that you all announced in previous Edgewood decisions did not say that there was a dollar amount that equaled minimum education.
Could it be just as, assuming that property wealthy districts had to round down to $280,000, and assuming that property poor districts were rounded up to $280,000, it's just as, could it be just as likely said that the property wealthy districts now have been reduced below the minimum educational ability to fund minimum educational requirement needs as it is to assume that property poor districts now are provided sufficient funding for minimum educational needs?
Your Honor, I think what the district court determined was that that was a political question that the legislature and the people of Texas needed to answer, but that it was never going to be asked until you got the property poor districts in the same boat with the property rich districts. And there's so many variables that go into what makes a good education. There's so much that is not related to money and so much that is related to money that it's very difficult to answer your question and just say this dollar amount would guarantee a minimum education, and if a school district goes $50 below that amount or $500 below that amount, there's no education that's adequate. Mr. Parker is here to tell you that he believes there's a remedy out there with the voucher system that would cost far less and would be far better. There are all sorts of theories out there about what makes a good education. And the variables are so great that what this court has accepted and agreed on is that money does make a difference, and that there is some reason to believe that everybody is better off if everybody is getting about the same amount of money, a substantially equal amount. If you get the low wealth districts up and you've got some equal level, then the debate about what the adequate level is can go forward. And the legislature and the people of Texas can make that determination. And it's a determination that obviously has a lot of cost associated with it. We're talking about billions of dollars to bring up every $100 of educational dollar that we spend on school children in Texas. We're talking about 4,600,000 average weighted average daily attendance in the state of Texas. So every time we increase the amount of money we're spending per student, that's a huge amount of money. Under Senate Bill 7, you've got over 3.9 million of those people in a totally equalized system. And the 690,000 that are outside of that equalized system are at most $600 outside of it. I think that there's no question that progress has been made. In 88-89, you were talking about $4.9 billion in state aid. In 93-94, you're talking about $7.3 billion in state aid. Since 88-89, the revenue has increased in the whole system by 30%. It's increased in the poorest districts by 56%.
Counsel, do you agree with Edgewood and related school districts that districts by vote of their citizens can increase their tax rate beyond $1.50?
Your Honor, the district court found, and we believe that Chapter 20.09 and Chapter 20.04 working together put a $1.50 cap on maintenance and operation. There's an opportunity for new debt to go beyond the $1.50 by 50 cents under 2009 and I think it's 20.02 by vote of the people in that district. And that, I think, was the only substance to the amendment that was made by Senate Bill 7 to 2009. Prior to Senate Bill 7, 2009 was capped at $1.50. The language that's at issue here is the language that has to do with a vote. And the district court found, and we argued, that that vote was only to raise debt tax, that there's an absolute $1.50 minimum or maximum on maintenance and operation.
Is that interpretation critical to your belief that this system is constitutional?
I think that it is within a $1.50 tax range that Senate Bill 7 attempts to equalize. And I think that to look at the amendment to 2009A as having destroyed the entire balance set up in Senate Bill 7 between Chapter 16 and Chapter 36 by last-minute amendment would destroy the intent of the entire bill. The bill is very carefully set up to give the greatest amount of equity that it could through Chapter 16 by controlling the disparity of wealth through Chapter 36. And it does it by equalizing up to what the maximum tax rate ought to be, which is $1.50 in this instance.
Is that also a minimum, in a sense, the $1.50?
No, Your Honor.
In order to receive Tier 2 funds, isn't it required that there be that the school district tax up to that $1.50?
No, Your Honor. At school district, the requirements to receive state aid are the local fund assignment requirements that have been in public finance since the Gilmer-Aiken. And under Senate Bill 7, there's the local fund assignment is set by multiplying an 86-cent tax rate against the property values, adjusted property values. That's Tier 1. Any tax over that is in Tier 2. And school districts would receive a guaranteed yield for those dollars. There's no compulsion to go to $1.50.
May I ask you, if the state can recapture taxes in excess of $280,000, the $280,000 level, and redistribute those funds to other school districts with smaller tax bases, what are the constitutional limitations, if any, on the state in recapturing all local ad valorem taxes and using that to fund the public school system in Texas?
That's not exactly what's happening in Senate Bill 7, Your Honor. It isn't, we've used the word recapture, but what's really happening in Senate Bill 7 is that the legislature has said we can't solve the Edgewood problem, we can't meet the Supreme Court's mandate without doing something about those districts that have this huge amount of disparate wealth, that are so much wealthier than any other district in Texas, that there's no way we can ever meet what they can tax to, and we can't provide that for poor districts. So what the legislature has done in Senate Bill 7 is say that no school district can tax beyond a $280,000 worth of wealth. And then it is said, okay, well, we can take that excess wealth and we can consolidate it with poorer districts, or we could detach and annex with poorer districts. That we have the authority to do, and that's what we would ultimately do in order to meet the mandate. We're now offering...
Some school districts receive zero state funds after it's netted out, and so in essence the local the taxpayers and the local school district bear the entire burden of educating students within their district, and the state pays zero. Would you agree with that?
Yes, Your Honor, but that's because those people have school districts whose boundaries encompass a disproportionate amount of the wealth of the state.
So you would contend that the state can discharge its constitutional burden to provide a public school system by transferring the entire burden on an individual local independent school district taxpayers, and by contributing nothing.
There's nothing in the Constitution that prohibits a reliance on property taxes. In fact, if you go all the way back to the debates in 1845, when the Educational Amendment first appeared, and the appendix to the Humble Brief quotes an article from Mr. Walker, which actually tells you that in those debates, the provision was that education was supposed to be paid for from a property tax. And that the reliance on property tax is nowhere prohibited. In fact, it's anticipated in the Constitution. If, in fact, a school district, by happenstance, by history, by whatever, is fortunate to have within its boundaries a disproportionate amount of the property wealth in Texas, then it is fair for the state to expect that the entire amount of money to pay for their education might come out of that property tax, so that the state can benefit those districts that have lower wealth.
Is there any similar constitutional mandate on the legislature to that contained in Article 7, Section 1, that imposes a burden upon the legislature where they transfer the financial burden entirely to local government, that you can compare this to?
I think it's conceptually, the answer to your question is no, I don't believe there is, but I think it's conceptually wrong to talk about this as though the legislature was transferring the burden to the local district. The legislature is paying for...
What else can you call it when the legislature pays zero?
The legislature is not paying zero, Your Honor. The legislature is paying 49%, 47%, 51%, whatever the figure is that you want to settle on when you decide to divide up. What is happening here is that property taxes, property wealth is disparate throughout the state. And the legislature has the right and is entitled to draw boundaries. It could draw boundaries where every school district in Texas had equal property wealth. It could then tax a certain percentage of that property wealth, and then it could make its contribution on top of that. The only way you can conceptually say that a school district like Highland Park is paying for all of its education is by saying that somehow or another Highland Park has a vested interest in its boundaries, that it is entitled to its property wealth, and Edgewood is not entitled to an equal shake at it.
Well, given the fact we have a constitutional prohibition on a statewide property tax, and given the constraints of Love versus City of Dallas that we reaffirmed in Edgewood 2 on motion for rehearing, how, for example, Stafford Municipal School District says that they, in essence, get no state aid and that the entire burden is put on them. Are you disputing their factual claim?
I'm disputing that you can look at the system of education by taking Stafford and saying Stafford is in and of itself a system of education, and the citizens of Stafford are paying for it all. Stafford is a part of a state system of education. The state is paying close to half of the cost of that education.
By using Stafford's money?
It's not Stafford's money, Your Honor. Stafford doesn't own, Stafford is not, doesn't have a vested title to its boundaries.
Let me ask you a question on that. Let's assume, well, is there value in where a home is in relationship to the school district? Is that a value in terms economically of the cost of a home depending on what school district it's in?
I think, Your Honor, that that's probably true.
Let's use a hypothetical that a home in Highland Park School District, to buy that home, you must pay about a 30% premium to live in that school district. Does that not undercut your argument that a school district is not entitled to the funds raised within that school district for education?
No, Your Honor, not if the state, not if this court and the state has the legislature has a mandate to make the educational system efficient, and if that definition of efficient is that every student in Texas is entitled to substantially equal access to revenue. The legislature has the authority to draw boundaries, it has the authority to rearrange boundaries, and by this court's opinion and by the Constitution, it must do so. It must make the wealth that school districts can draw on approximately equal.
If but that presupposes that there is no value market-wise for a home depending on the school district it's in. In other words, that presupposes that a home in one district would, for the bricks and mortar that is used, would have the same value as another home in another school district for bricks and mortars that are used, such that the taxing effort alone is the sole consideration for the revenue produced. But if a value in a home has a significant percentage based on where the home exists, then the revenue produced would be enhanced, not because of the tax effort, but because of the economic value, the appraised value of the home. Isn't that a situs-specific issue that has not been addressed in virtually any of this?
It's not been addressed, Your Honor. I suggest to you that it probably has to do with a lot of social factors, some of which we may or may not want to endorse, that we have an entitlement to equal educational opportunity for students that far offsets, I think, the vested property right you suggest a school district has in the houses that are within its area.
But it only becomes an issue if the state relies almost entirely on the property value within a particular district to fund the entire educational program in the state. It no longer is an issue if the state provides a state mechanism for funding for state schools.
What you're suggesting is that each individual school district becomes its separate system of education, and that if it has to pay its proportional share based on its wealth for that education, that it is somehow disadvantaged in the system, and because the state is moving its state dollars to the lower wealth districts as required under the Edgewood 1 opinion, that the state then doesn't get credit for supporting the educational system in Texas.
I think you made a jump there. Again, you go back to Justice Cornyn's question about recapturing from the local school district. If it was a state-funded program with supplements from property tax and local school districts, then that's one issue. If it's a state program funded entirely from local property school districts, local property taxes in particular school districts, then it seems to me it becomes an issue about what the state is doing in terms of education statewide.
I think what you're doing, Your Honor, is looking at an individual school district as a separate entity. It's not a separate entity. It wouldn't exist but for the system that the state of Texas is required to put in place. It's a part of a system of education. You are here today not to rule on behalf of a particular school district. The state is here as a lone defendant. It would be very easy, I think, to please many school districts by finding Senate Bill 7 unconstitutional. But your task is not to look at school districts as autonomous islands generating money for the education of their children. You're here to look at a system in Texas that is supposed to educate all the children of Texas, and that is supposed to consider how to do that and not pit one school district against the other and say, this is our wealth and it's only to be used for our children.
Ms. Hunter, given that the state of Texas is not a federation of autonomous, sovereign school districts, which number a little over 1,000 now, I don't know the exact number anymore, and used to number over 10,000. There has been some consolidation given the authority of the legislature to draw those district lines any way they choose and consolidate any way they choose. Given that, I'd like to ask you the same question that I asked Mr. Luna a little earlier, and that is, since the legislature clearly has the authority to draw those lines any way they choose, we could have 2 school districts for the entire state, or 3 or 4 or 5, any number up to what we currently have or more if they want to make them smaller. Given that option that constitutionally is vested in the legislature, if the alternatives, the voluntary alternatives that the legislature has provided for these local districts in lieu of consolidation, if any of them fails constitutionally, do all of them fail constitutionally? Does the scheme fail entirely?
No, Your Honor, I don't think the scheme fails at all. In fact, the bill itself has a contingency provision in 36.009, which allows each option to be severed from the bill and tells the Commissioner of Education how to proceed if any of the options are unconstitutional. And that, of course, is also what is provided for in the government code in section 312.013. And Texas case law provides that as long as what remains once an unconstitutional provision is stricken can go forward and meet legislative intent, it's incumbent on the court to let it go forward and give it its meaning. And clearly what the legislature intends here is to get to a point where it has created an equalized system where there isn't a huge property wealth in one area and not in another. So I believe that the bill could go on.
The legislature is well aware of its authority without local voter consent or anybody's consent to go forward and redraw district lines to equalize funding on an economic basis, to take that home and put it from one district into another simply by changing the contours of the district. They clearly can do that under the Constitution. I don't think anyone disputes that. They don't have to ask for the local superintendent, the local school board, or the local voter's permission. But they set up alternatives in this formula saying if the local voters don't want this, they can vote one of these other options. And it requires local votes, contrary to earlier legislation.
That's correct, Your
It
Honor.
requires them to voluntarily choose an alternative to consolidation. If they choose that, it's voluntary. It may be coerced by the specter of involuntary consolidation, but they don't have to go that route. They can go the route of involuntary consolidation, can they not?
That's correct, Your Honor.
Thank you.
Regarding the $280,000 standard, is there any constitutional impediment to setting that lower?
To setting it lower? No, Your Honor.
It could be set at $100.
Well, Your Honor, at a certain point, I suppose you get to the point where you don't have an educational system.
Well, no, at certain points you get to where all the money's going into the state treasury.
Perhaps. I don't know what
So
mechanism.
the question is, does the Constitution prohibit that? I mean, could you set it low enough to where virtually all of, or a large part of the local ad valorem tax were going into the state treasury?
There's no ad valorem tax going into the state treasury under Senate Bill 7. What you have under Senate Bill 7 is a local fund assignment. That's all you have. That's been there since Gilmer-Aiken. It's never been considered a state property tax. It's required that if a school district wants state aid, they have to raise their local fund assignment to get state aid. School districts who don't want to participate and get state aid don't need to raise their local fund assignment. The rich districts, the wealthy districts, are forced to raise the 86 cents, 87 cents, 88 cents, $1.27, whatever that figure might be that they say they're forced to raise, not because there's a state ad valorem tax in Senate Bill 7, but because of the realities of paying for education when you don't have a disproportionately wealthy tax base to draw on. That is what Edgewood 1 required. What offended the court in Edgewood 1 was the fact that Highland Park could tax at 40 cents and have $6,000 of revenue to spend per pupil. It was the disparity between poor districts who had to tax high and only could spend low, and wealthy districts that could tax low and spend high that offended this court in Edgewood 1. What Senate Bill 7 has done is made the system more even, and not even enough for Mr. Kaufman. Mr. Kaufman, I believe, if you asked him the question, would say that the $280,000 should be pulled down to more closely $205,000.
But you could make it perfectly even if there were a state ad valorem tax.
But there isn't, Your Honor.
And there isn't. And at some point, this approximates a state ad valorem tax, doesn't it?
I don't believe it does, Your Honor. I believe what it does, and it does nothing more than this, is flow from the legislature's authority to reconfigure school districts, to consolidate school districts. And the legislature can do that. It has the authority to do that. It could make every school district in Texas have exactly the same amount of property wealth in it. And that's what it would be doing if it did that. It would not be making a state property tax. It would be just reconfiguring the tax basis.
Do you concede that the state could not require each of the districts in the state to tax at a specific level and to render those proceeds to the state for redistribution for public education?
That, Your Honor, is what you ruled in Senate Bill 351 was a state ad valorem tax, because the state levied it, the state distributed it, the state mandated it. That is not what occurs in Senate Bill 7.
If the school district has no right to the ad valorem taxes raised within the school district, and as you said, that's a way the state realizes its constitutional duty to pay for public schools, why isn't that a recharacterization of a local ad valorem tax as essentially, why doesn't that make it a state tax?
Your Honor, I don't believe that I said that the school districts didn't have a right to their taxes that they raised. I said they didn't have a right to their boundaries. They didn't have a right, they didn't have a vested right to the property wealth that by happenstance is within their boundaries. That the legislature has the authority to redraw those boundaries.
That only happens if they don't accede to the 5 options available to them in order to writing a check or educating students from other school districts, that the detachment and annexation process takes place.
They are given a choice under Senate Bill 7 to avoid the detachment and annexation or the consolidation.
But short of that, you say the funds that the local ad valorem taxes remain the property of the local school district?
Yes, Your Honor.
So they're not, the state has no right to those funds?
Under option 3 and option 4 in Senate Bill 7, one of the choices that a district can make is to either contract with another district to educate students within that district. Therefore, there's some transfer of money from one district to the other, or it can choose to buy weighted average daily attendance from the state, and thereby it sends some money to the state, which is redistributed in the system. But those choices are made with voter approval, and they are choices. There's nothing that tells a district that they have to make those choices. The other options are options that have been around for a while. Tax-based consolidation has been approved by this court in Edgewood 3. Consolidation has been around for a while, and voluntary detachment and annexation has been around for a while and never been challenged as unconstitutional.
Counsel, let me ask you a few questions about the appellants who don't fit neatly into the rich district or low district paradigm. Why can't the Gutierrezes make a claim that efficient and suitable means something beyond what earlier litigants have presented to us in Edgewood 1, 2, and 3, and more akin to what some of the other Supreme Courts have held? Why doesn't that state a claim that the district court should grant a trial on?
Well, I think the district court correctly determined that what the Gutierrezes were doing was raising a political question, a question that belonged to the legislature to determine. In one way of looking... What's
the principal distinction between the words efficient and suitable as they relate to how much money is being distributed and efficient and suitable as they relate to the outcome that's being achieved?
Several things, Your Honor. First of all, the standard that the court would apply, the court looked to Baker v. Carr to use the standard for a political question. And it determined that if it's constitutionally committed to another branch of the government, the court should not intrude upon that. In Edgewood 1, this court reversed an appellate court decision, and we contend you did that very narrowly. You looked at efficiency through a fiscally neutral standard. You defined that as what was justiciable, what was something that courts could look at, and did not scoop up the entire area of education and decide that the court was going to determine what a good education was, what a proper education was, what the right method for getting a good education would be. The voucher system is one remedy. It's one among many remedies that the legislature could utilize. It could experiment with that. It could experiment with other forms of education. the court did not take up, I think, in Edgewood 1, the entire question and all of the sub-questions that have to do with education, but said very narrowly, what a court can do here is look at whether or not one group of districts has getting equal access as compared to another group. That's a justiciable question. That's
Do you disagree with the history that Gutierrez's brief relates up to 1876?
Yes, Your Honor, I do. I think that...
So it's not just what's happened in the last 100 years in terms of amending the Constitution, but you disagree with the very premises.
Yes, Your Honor. I believe that the legislature long ago chose school districts as the method of delivering education to children in Texas. It doesn't. School districts aren't precluded from contracting for services. There are ways that they could enable their constituents to do the sorts of things I think that the voucher system would envision. But giving money to parents and letting them go out and purchase their education is not constitutionally required, and it's not what the legislature has at this point chosen. And I think that's a political question for the legislature.
And finally, on the Somerset ISD's claims.
Yes, Your Honor.
Why didn't the commissioner either exceed the authority given to him under the statute, or else the statute be an unconstitutional delegation?
I think that the statute gave the commissioner the authority to distribute these excess CED monies in a way that fit with the system. He made a choice to distribute them in a way to make the transition from Senate Bill 351 to Senate Bill 7 less difficult for certain low-wealth property districts by giving the money in inverse proportion to what they lost in dollars in that transition. And that is keeping with the standard of the Act. I think it meets the legislative purpose of the Act, and it is not at all outside of his authority. Somerset has its dates mixed up. The August 31st deadline in the order merely allowed those monies to be considered for 92, 93 tax purposes. It had nothing to do with Edgewood 3. The court here said that June 1, 1993 was the date by which the legislature had to put a new system in place. It did that. You specifically ruled in Edgewood 3 that the opinion was not to be used as a defense to the collection of those taxes. All of that money is supposed to come in, and that money is, as you ruled in Edgewood 3, state money, and can be distributed in a manner that's appropriate, and that's what the commissioner was delegated to do, and that's what he did.
Any other questions?
So let me ask you to comment on an assertion made in one of the briefs that the experts at the trial court unanimously agreed that the $2,300 was inadequate to fulfill the purpose of providing a basic program for education for all our students. And how does that relate to your argument that this is constitutional?
The $2,300?
Is on Tier 1.
Yes. You know, I think that what's happened as the legislature has looked at trying to meet the Edgewood mandate is that the distinctions between Tier 1 and Tier 2 have become less meaningful in terms of what is a basic, what's being provided by the state for basic education. I think it's much more appropriate to take a look at what the entire equalized amount is, and that's in the $3,000 range. As a part of the trial exhibits that was introduced, the difference between the LBB recommendations, which some of the parties said would have been better, and if you take a look there, the LBB recommendation set the Tier 1 at $1.15. Senate Bill 7 ended up doing it at 86 cents, but it ended up equalizing to a much higher amount. And I think what's happened because of the emphasis on fiscal neutrality is that what we're really looking at in the different tiers right now is which way to finance the system, which way works best, which way creates a more equitable system. And it's really probably not as fair to attach a minimum basic education to Tier 1 as it would be to just look at, well, what is the state guaranteeing to everybody? what is the minimum that the state guarantees every school district in Texas. And I think that there then is much more room for saying, yes, that's makes an adequate basic education possible.
Do you share the view of some legislators that, given the political realities and the public comments made by our elected leaders who have to struggle with this issue, have been struggling with this issue for several sessions, that this is the best it's going to get?
Your Honor, I think that I would agree that this is pretty good. I don't know that I would agree with it in the sense of saying, oh, we give up, this is the best that can be done. But I think what the legislature did this time was to really take hold of the hard realities that you put in front of it in your Edgewood opinions when you told them that they needed a radical change in the system, that just pouring more money in wasn't enough.
But there have been no structural changes in the system?
There certainly have, Your Honor.
What structural changes can you point to?
The structural change that is just so important for the court to realize is the limitation of wealth to $280,000. That is a monumental structural change. That's what makes it possible. Without that change, there's no way you could meet the equity that Edgewood wants. You couldn't get as close as this bill has gotten without that structural change. What was offensive to the court in Edgewood 1 was those districts that had 700 times the property wealth of another district, who could just tax, could bring in whatever they wanted at a very low tax rate. They could bring in tremendous amounts of money at a tax rate which was a third of the state average. That is an incredibly important structural change that changes the map in Texas. That means that 85% of the students in Texas live in an equalized system.
Well, all that may be well and good, but how could it possibly be when we equalize the system and you're leveling down that we're making some improvements, that we're going forward instead of backwards?
Because you're eventually going to make everybody go to the legislature and push for it to go up. What you're talking about, Your Honor, is a system where, I don't know if you can see this or not, but in '89, you were talking about a system, this is where the '89 system was in terms of revenues that were equalized. And you can see a lot of revenue was out of the equalized system. Under Senate Bill 7 in 93-94, almost all of this revenue that hits the 100% line is equalized. There's only these very small areas where you have unequalized revenue. Now, one school district having to come down a little bit so several school districts can come up means that that's a unified voice saying education in Texas needs more money. And if the citizens of Texas agree, yes, we need more money, we need to raise more taxes for education, the legislature will do it. But as long as you let 99 school districts be the best school districts in the state and don't worry about the remaining school districts, nobody sees the problem.
Any other questions? Thank you, counsel. Court is now ready to hear a rebuttal argument from Edgewood ISD and others.
Your Honor, may it please the court. We feel that the legislature, we the Edgewood plaintiffs and plaintiff interveners, the legislature certainly did not do all that it could have done within available resources. In fact, the system could have been made suitable to fit the Edgewood test with the available resources. It could have been done by redistributing the available state money fair and not taking money away from poor districts. It could have been done by maintaining the very strict tax rate limitations that were in Senate Bill 351 instead of weakening them. It could have been done by actually moving the $280,000 figure down to a figure to which the state could equalize, more like $250,000. And it could have been done by using the state's power to consolidate, which I think there's no legitimate objection to the fact that the state does have that power.
Well, we may have a theoretic power, but in reality, it's such a sacred cow. Do you ever foresee real consolidation?
Well, yes, Your Honor, I do. I think that under the pressures of this court and the pressures of need for education in the state, that there's more and more of an understanding that some consolidation is going to be necessary. It is a method that could be done. The other methods also could have been done. Now, if the court's question was whether politically you could ever pass anything that would get 2/3 of the vote, remember now, because of the time limitations, they'd get 2/3 of the vote in each house. I'm not sure you can do a lot better and get 2/3 of the vote. I think you could do better and get half of the vote. And if the bill had been passed early enough, it could have been done with 76 votes and 16 instead of 121 necessary. On the issue of facilities, which we haven't covered, I want to tell you a brief story about my being in Edgewood on Monday. We had a presentation in the cafetorium in Edgewood. Edgewood High School does not have an auditorium, doesn't have a cafeteria. It's combined one room. So they cannot give a school program and eat at the same time. All the school programs have to be done around the eating times. Then we looked at the labs. The labs in Edgewood, and this is a large school in a large school district, are not what we had at Ball High School in Galveston when I graduated in 1965. They're certainly far inferior to what's available in the wealthy districts in this case. As I walked out of the school district, I saw a long line of students who were profoundly mentally and physically handicapped and were educated in the school district there at incredible cost to the district, not only in terms of needing one teacher for every 2 or 3 students, but in facilities needs, because those students must be taught in their own space, in their own way, with their own special equipment. We have a $3 billion gap that the state has found in its own study just to bring the districts in the state up to an adequate level. There's a tremendous history of deprivation in these school districts that we represent. I mentioned Edgewood and its needs. I also represent Socorro, which has gone from 7,000 to 18,000 students in the last 10 years, and has had to spend almost half of its tax rate on facilities. It simply cannot make it under the present system without facilities being covered. In terms of the options, there were questions about the options. We want to make it clear that if the options fail, in other words, if this court were to find that the school districts could not be forced to accept one of these options, or that the legislature could then not force the districts to consolidate, then the whole bill fails. And I think that Ms. Hunter honestly agreed to that if you could not bring these districts to the $280,000 level, then this system certainly fails. If you can go above a $1.50 tax rate, as we have argued, the system also fails. The recent Spring Branch lawsuit has found a hole in that would allow 1/3 of the students in the state to go above $1.50 for any purpose, including M&O. The state has agreed that districts can go up to $2, so the graph that we have shown you is indeed the system that will be in place. Now, in terms of the state's promises, we are not asking, we talked to my clients about this last night, and they said, well, you know, the state should have paid it, and they didn't keep their promise. I said, well, we're not going to get the Texas Supreme Court to say that the Texas legislature lied to the people. I mean, that's not the way these issues can be done. What we want to argue to you, though, is that you should not find the bill constitutional because of a promise to pay in 1995-96. Those promises were not kept in House Bill 72. Those promises were not kept in Senate Bill 1. And the promises for funding in Senate Bill 351, regardless of the structure, the promises for funding were not met. If the Senate Bill 351 levels of funding had been met, this year every district in the state would have $500 more per weighted student. So that promise was broken. In terms of the $600 figure, Dr. Meno agreed that $600, even if you limit it, that's all the variety in the bill. Dr. Meno agreed that that is a substantial amount of money and can affect education in the context of Texas school finance. That's, I guess, my 5 minutes. I just wanted to say that I do agree with Ms. Hunter on something. I want to make sure that I have read my Bible closely. I know about Solomon here. We're not going to give up half of the baby of Edgewood 1 in order to win this case. Edgewood 1 was 190. Edgewood 2 was 190. There were issues throughout that litigation on the propriety of school districts' property and their unique and sole exclusive use of property in that district to support their schools. That was argued extensively before the trial court. It was argued before this court, and we won on that issue. This court has found, and indeed, I'm sure this court will not back off of those findings, that this is a state system and the state must use all of its resources efficiently. We would ask you for sure not to back off of that holding. Thank you very much.
Any other questions? Thank you, counsel. And the court is ready to hear a rebuttal argument from Carrollton Farmers Branch ISD, Coppell, and others.
May it please the court. My name is Deborah Hankinson. I represent the Coppell, Grapevine, Colleyville, Highland Park, Miami, Plano, and Richardson independent school districts. The state has characterized Senate Bill 7 as a complex law. Any way, though, that the state can characterize it or any terms that they use cannot disguise the fact that the cornerstone of the statute is an unconstitutional tax. For that reason, the savings clause cannot save it. Regardless of how the wealth reduction options are characterized, they result in an unconstitutional property tax. I have heard the state make two arguments that I would like to address. First, the state has said that because they have the authority to consolidate or change boundaries of school districts, they can force school districts to make a choice to give away property tax revenue or property tax base. And second of all, that nothing in the Constitution prohibits them from relying upon the property tax in the way that they are doing in this law. I suggest to you that both of those propositions are wrong. The state is basically saying that they have a legal right to discipline school districts by changing boundaries or consolidating. Yet, in an analogy, the Constitution says, the law says it's illegal to shoplift. The Constitution contains prohibitions. The state cannot threaten the school districts, just like a parent cannot threaten a child with discipline if the child refuses to shoplift in violation of the law. The argument that the state is making that it can consolidate and change boundaries, absolutely, and therefore it can force the districts and taxpayers of the state to do something unconstitutional and illegal, has been presented to this court before. That is...
I'm having a difficult time understanding why it's unconstitutional for just one of the options that's available, why it's unconstitutional for the voters in a local district to vote to send some of their money to another district, or to vote to contract with another district to educate some of its children.
Your Honor, I would suggest to you that the only vote that matters in being allowed to do that would be a vote to amend the Constitution. This court has repeatedly viewed the Constitution as a limitation on taxing power. We have an absolute prohibition in Article 8, Section 1E against state ad valorem taxes.
When the local district votes to do this, when the people voluntarily, of that district, the voters voluntarily say, we will educate some of your children, or they voluntarily say, we will transfer these funds from our excess wealth over to you so that you can educate those children yourself. What provision of the Constitution is violated when the local voters of that district vote to do that voluntarily?
Article 7, Section 3. This court in City of Fort Worth v. Davis in 1882, in Parks v. West in 1908, and in Love v. City of Dallas in 1931, said that that provision operates as a limitation on the taxing power to tax for education, and that no implied power can be read into it. All that Article 7...
You couldn't do it without a vote without the consent of the district.
No, what it says in the provision, Your Honor, is that the legislature may authorize local districts to levy an ad valorem tax to supplement for the further maintenance and operation of the provision of facilities in the district, provided the voters vote to do that. There's nothing in the Constitution that says that Article 7, Section 3 allows voters to vote under that particular provision to send money out. This is a vote that didn't make any difference. That's why we had the constitutional amendment on recapture. That's why the legislature's response to the Edgewood 3 opinion was to go to the voters and say, give us the constitutional power to let your property taxes go out of your district and to someplace else. I suggest that under the authority of this court, Article 7, Section 3 operates as a limitation. And the only thing that is authorized is for the legislature not to order, but may authorize local districts to tax for spending within that district. This vote made absolutely no difference because it cannot be implied and it is not expressed under that provision.
Counsel, do you say that all 5 options, Violate, Love,
I say that all 5 options violate Article 8, Section 1E, and also Article 7, Section 3. I
If
heard-
one of these options were unconstitutional, in your opinion, and the other 4 were not, I think you would agree the savings clause could operate in that instance.
I don't believe the savings clause can operate to save any of the options because...
Let me
Okay.
restate my question, or repeat it, actually. If the legislature gave 5 options, and you believed that one of them was unconstitutional, but the other 4 were not, the savings clause would say that, and the scheme would go on with 4 options.
Not, Your Honor, if the underlying cornerstone of the financial structure of that law resulted in an unconstitutional tax. And each of the options would require the imposition of the
But
unconstitutional
that's,
tax.
you're saying that all 5 options are unconstitutional.
I am,
I'm asking a
Your Honor.
hypothetical, I don't think
Oh,
you're
yes.
going to answer it.
I am, Your Honor.
If you believe that all 5 of these options violate the Constitution, can the savings clause nevertheless operate to say that one of the 2 other measures, that is, changing boundaries or consolidating, will be implemented on those districts that exceed the wealth cap?
No, Your Honor.
And why not?
I don't believe that that's the case, because even if the involuntary options were left in place, the law is still based upon an unconstitutional state property tax. I heard Ms. Hunter saying that the 86-cent tax was mandatory. The state's position that fiscal neutrality can be obtained under this law is dependent upon property taxes going to $1.50 around the state. Now, we have the problem with the prohibition against state property tax and the limitations of Article 3, Section 7. If the involuntary provisions came into play and we were down to 3 school districts around the state, we would still have in place the mandatory tax provisions ordering those school districts to tax at a certain level, and there is no authority in the Constitution that allows the legislature to do it. In fact,
But the legislature can consolidate school districts for any reason or for a bad reason.
I disagree, Your Honor. I do not believe that the authority of the state to consolidate school districts is unlimited. Certainly, there are other considerations that are at play at that. The state has taken the position in any challenge made by some of my co-parties to the particular provisions of consolidation that it's too early to say that because the mandatory provisions have not been put into play, we don't know the impact of them.
What are the limits that you believe on consolidating?
I believe that Article 7, Section 1 has limitations in terms of the type of educational system that needs to be in play. One large school district around the state could hardly be efficient in terms of the importance of local control and that type of thing. I also think in one of our footnotes in the brief, we discussed the historical, constitutional aspects of consolidation and boundary changes. It's very clear that since the provision that allowed the establishment of school districts was added to the Constitution by amendment in the late 19th century, at that time, the enabling legislation, once school districts were set up, required a local vote in order to change boundaries. And every statute, with the exception of the dormant school district statute since that time, has in fact had that requirement. I think
You're saying that the efficiency clause of Article 7, Section 1 limits the very clause that is at the heart of Edgewood 1, that it limits the power of the state to consolidate districts.
I think it does, Your Honor.
And is
I don't think
there-
they can do so without consideration of the impact upon education.
So other than the efficiency clause, which formed the basis for Edgewood 1 and this entire school finance litigation and our decisions, is there any other provision in the Texas Constitution that exists today which you say limits the power of the state to consolidate school districts?
I think that interpreting the historical background behind Article 7, Section 3, and it is cited in a footnote to our brief, that
Right.
that interpretation would also limit the authority of the
I'm
state to
familiar with your
consolidate.
footnote, and isn't all that again tied to Article 7, Section 1?
Also Article 7, Section 3, Your Honor.
Thank you.
What was your other point that you wanted to make? You said you started out with about 2 points. Can you do that briefly?
My point is that the state took the position that nothing prohibits what they've done here, and I would suggest to you that the prohibitions on taxing authority do prohibit what they've done, because I believe this is a mandatory tax. It runs afoul of all of the requirements, what this court defined as a state ad valorem tax under Article 8, Section 1E in the Edgewood 3 opinion. And as a result of the fact that the tax is a mandatory tax that does violate that prohibition, there is something that prohibits it. Ms. Hunter said the money doesn't go to the state. It goes into the state treasury when the money comes to Austin before it's redistributed. The tax rate is not discretionary. It's stated in the statute. Accreditation is required. The state is using now the local districts as opposed to CED as taxing agents. The money is distributed statewide. The district court even called it state dollars. I've also already mentioned the fact that Article 7, Section 3 as well limits the taxing authority, and I think that that is part of it as well.
Are there any other questions? Thank you, counsel.
Thank you.
That concludes the argument in this cause. The foregoing cause is submitted on briefs and oral arguments. It concludes the court's oral submission docket for the day, and the marshal will now please adjourn the court.
The audience will please rise. Oyez, oyez, oyez. The Honorable Supreme Court of Texas now stands adjourned, subject to call.